All right, so I'll see y'all at 9:30.
Judge, I have to ask you, is this a tactic on the court's part to attempt to wear out the defendant so they can't access their right to trial?
Oh. I find that very inappropriate to say when there is no proof and people are just throwing things out. Now, what I can tell you, and I'm sure your client is aware, sometimes when we end up coming to court, we come to court because there are discovery issues.
Before we even get into the facts of this case, pay close attention to the tension in this courtroom, because this isn't just about scheduling delays or paperwork. This is about power, patience, and the pressure placed on defendants who are simply trying to exercise their right to a fair trial. Presiding over today's docket is Judge Stephanie Boyd, and from the very first exchange, you can feel the friction. Attorneys are frustrated. Defendants are missing work. Records aren't being taken. And one question hangs in the air that instantly raises eyebrows. Is this process being dragged out on purpose? The defense suggests the repeated delays are creating hardship, financial, emotional, and professional. The court pushes back hard, pointing the finger at attorneys, crowded dockets, and jail overcrowding. But when YouTube recordings are mentioned and the official court record isn't rolling, things take a turn from procedural to personal. As this unfolds, you'll see arguments over discovery, courtroom protocol, expert witnesses, and continuances, all while the defendant, Juan Carlos Rios, waits in limbo. The stakes here are real. Missed workdays, expert availability, and ultimately, whether justice is moving efficiently or slowly wearing someone down. So as you watch this play out, ask yourself, at what point does courtroom efficiency cross the line into unnecessary hardship? And who really pays the price when cases keep getting reset?
So that's what happens. So then what ends up
Hey,
happening?
there should be a record, right?
Excuse me, stop interrupting me.
Well, we're not on the record,
Stop interrupting me.
right? I mean, we're not in
Stop
court. There's no record.
interrupting
So then
me.
my other question, I guess, is if you're not doing this to
So-
cause the hardship, it obviously causes all of the attorneys and the defendants. Are you doing this for the YouTube? Because we don't have a record, right? Except for the YouTube.
Yes, here's the thing. You're to be back tomorrow at 9:30.
Who's here on Juan Rios? Juan Carlos Rios, who's the attorney?
Right here, Your Honor.
All right, I'm gonna ask you the same question that I asked everybody else. Has an acknowledgement of discovery been done, because I don't have it in the court file?
I have signed a few of them at this
All
point,
right, so has there been any new discovery?
not to my knowledge.
All right, so you can make sure that the acknowledgement of discovery, the state actually has it and the court has it, because it's not in the court file, and obviously it's doing it on its own. So I'm gonna have y'all come back tomorrow. You're not number one on the docket. There are a couple of cases that are ahead of you, so those cases may end up going before yours. We'll just see where we are, okay?
That's correct.
Respectfully, Your Honor, Mr. Rios always appears, always waits all day. This is impacting his employment. We would ask that if we're not likely to be called tomorrow, that we be released. Additionally, I have experts for this trial that we have attempted to bring in, but we never know, and because the case is older now, when we should bring those experts in. So I'm gonna have to approach the court and request additional funds for those experts if we're reset. So I would ask the court either to give us some preference tomorrow for trial, or if we can't do that, to release Mr. Rios so that he can go to work.
All right, be here exactly at 9:30, okay?
Okay, yes.
All right, I'm supposed to be here exactly at 9:30.
You understand? Now, Your Honor, respectfully, every time we come to court, we lose an entire day of work ourselves too. This is not typical of most of the courts in this county.
Oh, yeah, it is very typical.
It's not.
Yes, it is.
You can say that, Judge, but I practice in
And
the
say
courts.
that, and it very is typical, because every attorney that's here has a case that's set for jury trial. And this is what ends up happening.
What ends up happening is I will allow people to go to civil cases to be out of county, and then their client is sitting here waiting for them. And for some reason, that's the court's fault. That's not the court's fault when attorneys are not showing up at 9 or whatever, and then they stroll in at 9:30 or 9:45. So what I'm telling you all, 9:30, see y'all at 9:30. Thank you. Coordinator will give you a reset form.
This moment right here is critical. The defense raises a concern that many defendants quietly deal with, but rarely say out loud. Repeated court appearances don't just cost time, they cost livelihoods. When Judge Boyd insists this is very typical, she's asserting courtroom authority, but also setting the tone. The responsibility, in her view, falls largely on attorneys, not the court. Legally speaking, judges do have wide discretion over docket management. However, that discretion must be balanced against a defendant's right to reasonable access to trial without undue burden. When defense counsel points out that entire days of work are being lost, that's not just complaining. That's laying groundwork for a due process concern. The tension escalates because the court sees this as an administrative reality, while the defense sees it as systemic strain. And notice how Judge Boyd frames the issue. Attorneys choosing to be in other courts first. That framing shifts responsibility away from the bench and squarely onto counsel. The question for viewers is this: if a defendant keeps showing up on time, but their case never gets heard, where does accountability truly lie?
Understood. Your
All
Honor,
right,
I'm
thank
trying to make
you.
a record. I don't see the court reporter typing.
What?
Okay, so we only take a record in this court when the judge tells you to? The case was called.
No, the case wasn't called. When I call the case, I call it by the style of the case.
Okay.
All right? All right, so I'll see y'all at 9:30.
Judge, I have to ask you, is this a tactic on the court's part to attempt to wear out the defendant so they can't access their right to trial?
This is the moment where the courtroom temperature spikes. When the defense directly asks whether these delays are a tactic to wear down the defendant, that's a serious allegation, and Judge Boyd reacts immediately. From a legal standpoint, accusing the court of intentional delay without evidence is risky, and the judge makes that clear. But here's why this exchange matters. The defense isn't just arguing logistics, they're questioning fairness. Judge Boyd responds by offering context from her own experience as a former defense attorney, explaining why she now enforces strict schedules and lunch breaks. Her explanation highlights a real courtroom dilemma. When judges bend rules, attorneys sometimes exploit that flexibility. Still, perception matters. To defendants sitting in the gallery, repeated resets can feel punitive even if they're not intended that way. The law doesn't require perfection, but it does require reasonableness. So let's pause here and ask, does intent matter more than impact? Even if delays aren't deliberate, should courts do more to minimize the toll on defendants?
Oh. I find that very inappropriate to say when there is no proof and people are just throwing things out. Now, what I can tell you, and I'm sure your client is aware, sometimes when we end up coming to court, we come to court because there are discovery issues. Sometimes when you're in court, you are in court because your attorney is late. And when I say late, I mean that when a case is scheduled in this court and it's scheduled for 9 a.m. and attorneys go to different courts because they want to go to different courts first, it is not the court's fault that you're sitting here for 12 o'clock or 1:30 or coming back over break. Number one, I have a lunch break. And there was a point in time where I would not take a lunch break. And the reason why I wouldn't take a lunch break is because I said, you know what?
Make a record?
I've been a defense attorney. And when I was a defense attorney, what I would always do, I'm like, I have to be in like 5 courts. It would be nice if if they could stagger their docket. And so sometimes I would be here, we wouldn't have a lunch break, and I would be here till 3 o'clock. And then you know what I discovered? When I would say that I'm going to be here till 3 o'clock, I'm working through lunch, other attorneys, you know what they would end up doing? Then they wouldn't show up in the morning. They would just show up at 1:30 or whatever, because they're like, oh, the judge is going to stay there. So I stopped doing that because I need a lunch break. And that's what happens.
So then my other question, I guess, is if you're not doing this to cause the hardship, it obviously causes on all the attorneys and the defendants. Are you doing this for the YouTube? Because we don't have a record, right? Except for the YouTube.
Yes, here's the thing. You're to be back tomorrow at 9:30. You
Yes.
understand?
Yes.
All right, thank you so much. And once you sign the reset form, you'll be here tomorrow. If somebody goes before you, somebody goes before you. Your counsel is well aware, or should be well aware, if he's been practicing in Bexar County,
For almost
that
20
there
years.
are a lot of cases that are on the docket for jury trial. So for example, I had approximately 40 cases down for jury trial today. And what ends up happening, sometimes people who are in custody take precedent because their cases are
I'm
older than
asking for a
yours.
record, by the way.
You understand? Because they're older than yours. So that's what happens. So then what
Complaints
ends
are
up
being made, there
happening,
should be a record, right?
excuse me, stop interrupting me.
Well, we're not on the
Stop
record,
interrupting me.
right? I mean, we're not in
Stop
court. There's no record.
interrupting me.
Sir, here's your reset form at 9:30.
So what ends up happening, sir, is that people who are in custody, sometimes their cases take precedent. And the reason why it takes precedent is because their cases are older and because the jail is overcrowded. Now, as you may or may not be aware, I call the docket all the time at 9 a.m. And sometimes when I call the docket at 9 a.m., defense attorneys are not here. Your attorney knows when he has not been here at 9 a.m. And then you have to wait. And you
Judge,
need
you're
to
aware
be
that every
here.
court starts at 9.
And you need to
I have
be
other
here.
cases.
And you need to be here at 9. So when your attorney is somewhere at another court, you know what ends up happening? Your attorney has made the choice to have you sit here and go to another court before
Well, that's
coming
not
here.
exactly true
You
because all of
understand?
those courts got
All right,
business
good luck to
accomplish.
you.
All
Thank
of us
you.
got
Thank you,
recalled
sir.
today,
Thank you,
right,
sir.
Judge? So, I mean, what did we accomplish?
Have a nice
today?
afternoon, sir.
I mean,
Sir,
that's the reason I don't come to your court at 9, because I know in another court,
Sir,
something's
here's your
gonna actually occur.
sir.
And they're courts of exactly the same
Sir.
jurisdiction.
Right this way, sir.
Yes. All right, thank you. Hi. All right, Mr. Guzman.
Yes.
All right, so before the interpreter came, and correct me if I'm wrong, your attorneys came forward to let me know that they just received a new indictment. Is that correct?
Yes, Your Honor.
All right, and so that indictment, excuse me. Step away.
I was doing what the court ordered me to do and checking on the discovery.
All right, so what ended up happening is your attorneys. All right. One things have really changed the way people treat people, which I find very odd. All right, so anyway. Juan Carlos Rios. Juan Carlos Rios. Yes. June Bright. June Lorraine Bright.
Yes. That's why.
What was that?
And that's the one that says that's the.
All right, the court is calling 2025 CR 005931 State versus Ricardo Javier Reyes. Can I help you? Juan Rios. Hi, you're on this side, your client's in the middle. What are we here for? Good morning.
Your Honor.
You were late.
That's why I was bringing him up.
All right.
But we are also setting the trial.
Yes.
We have a motion for continuance on file.
All right.
I don't know if you want to address that now or later.
Oh, do you have the motion for continuance? All right.
Give you a written copy. The state received it.
I've had a chance to review it. I don't have a copy with.
All right. So if you want to, you can make some copies and back and then confer with the state.
We've conferred about it. There are just a couple of matters that we need to make the court address.
All right. So if you'll make copies in the back. All right. Just have a seat. You're welcome. All right. Thank you. Juan Rios. All right, the court is calling 2023 CR 6483 State versus Juan Rios. Can I have parties announced?
Megan Galloway for the state.
Joseph Holscher for Mr. Rios.
And you are Mr. Rios?
Yes, ma'am.
All right, you're scheduled for jury trial today,
Yes.
and you filed a motion for continuance.
Yes, Your Honor. So in this case, there are three different blood tests.
Mhm.
We have an expert, Mr. John Castle. Mr. Castle I think he was embarrassed to put it in writing. He has a UTI, and I think it's developed into a kidney infection. So because he gets treated through the VA, apparently there was some delay in him getting the UTI addressed.
Mhm.
He has a set of appointments scheduled to put him on antibiotics. We conferred with the state on dates, but he's unavailable now. And I really do need a blood expert because, like I said, there's three separate blood draws and tests in this case.
State.
Judge, I conferred with Mr. Wilshire. We are ready to proceed today, but I'm not objecting to his motion.
All right, so when was the expert retained for this?
He was retained, gosh, maybe 2 years ago, a year and a half ago.
All right, so you need to find out from your expert when he's actually available.
We put that in the motion and the state conferred on 2 dates with us. So I think they were saying they were pretty packed on November 17th, and the alternate date, the state said that they would have all of their people was in February.
Well, no, I mean, it's saying that he's not available to appear October 14th through 17th. So
He has his appointments.
those when he has his appointments.
He
So-
also was given a home.
So someone needs to see for the court, and I need it in writing, whether or not he's available on the 20th.
October 20th.
Yes.
Okay,
I mean, no, we can start jury trial this week. He
Sorry.
just. So,
I understand.
all right, thank you.
Uh,
So you all, yes,
Sorry. I think in the motion, he said when he would be available. I think there was a date. I apologize. In his email.
I'm not sure. So the version that I had, it contained like an exhibit A that was attached. Does the court have that?
yes, I do. So we can still, it seems here. He says he's unavailable through October 14th through the 23rd. So y'all need to talk to him, and if he's available next week, we can do jury selection today and then continue it through next week.
I'll give him a call and come back.
Yes. All right, who else? Thank you. Who else is ready? All right, Juan Rios. 6th time is the charm.
Oh,
All right.
The call did not go as expected.
Oh, it did not?
I know, he can get on the record if you want.
Sure. Oh, what is it?
He's in hospital. He apparently has blood clots in his lungs. So when I called him and I sent Miss Galloway the text that he sent me of his hospital wristband.
This development dramatically shifts the legal landscape of the case. The defense's toxicology expert, a key witness due to 3 separate blood draws, is now hospitalized with blood clots in his lungs. That's not a scheduling inconvenience. That's a medical emergency. From a legal perspective, expert testimony is often foundational in DUI and intoxication-related cases. Without it, the defense could be severely prejudiced. Judge Boyd does exactly what the law requires here. She demands documentation, timelines, and clarity before ruling. This isn't skepticism, it's judicial diligence. The prosecution notably does not object to the continuance, which signals acknowledgement of the seriousness of the situation. At the same time, the court raises an important point. If the expert's availability remains uncertain, the defense may need to secure an alternative witness. This moment underscores a key truth about the justice system. Fairness doesn't just depend on rules, but on real human variables like health and timing. And sometimes, even the strongest case plans fall apart unexpectedly.
So I don't know when John Castle is going to be available at this point. I apologize.
Judge, he did provide me that information that he stated. So I conferred with him previously about dates that would work consistent with the Exhibit A that was attached to his motion, which was November 17th, I believe, is what the witness indicated the earliest that he would be available. So I did let Mr. Wilshire know that I do have a case that may proceed to trial on the 12th of November. So I'm not sure if that case will carry over.
All right, what page is this case on?
But November 17th, and then the other date in February, I believe we were agreed upon those two dates.
All right, this is what we're gonna do. Norma, recall this case for. All right, this case is gonna be recalled for October 16th. I'm gonna need some better information on what the status is. And at that time, the court will make a ruling on your motion for continuance.
Thursday, Judge, you here?
Yes.
9 a.m.
Yes,
Does Mr. Rios need to attend?
yes.
Just checking.
All right. Is there anything else?
Not at this point, Judge.
All right.
Kind of concerned that we might have to trouble.
Well, don't put that in the universe.
Yeah.
All right. We will see you back then. All right, Juan Rios.
We shared these with the state. These are letters from witnesses hospital.
State, any objection to the court review on this?
No, Judge, I've had a chance to review them this morning.
Okay. Oh, this is blurry.
I'm sorry.
That's okay. All right, the court is calling 2023 CR 6483, State versus Juan Carlos Rios. Can I have parties announced for the record?
Megan Galloway for the state.
Joseph Holscher for Mr. Rios, ready on our motion for continuance, but not ready.
All right, so with counsel, with regards to your motion to continuance, are you seeking to amend to include this as an exhibit?
I am asking to include it as an exhibit, Judge, the two letters that I've given you, we can mark them collectively to fix.
Okay.
I've tended to the court what has been marked as Defendant's Exhibit 1, which is two letters
Everyone, please whisper.
from Shannon Medical Center, which is a hospital in San Angelo, Texas. Our expert, John Hassel, was admitted to the hospital on Sunday evening and was in the process of still being diagnosed. They said he had blood clots in his lungs when we came on Tuesday, and the court had asked us to get more paperwork than the photos he sent us of his hospital bracelet. So we've managed to get that paperwork, but unfortunately, they cannot give us a date when he will recover. It just says that he will be expected date is to be determined pending further medical stability, and that he is unable to attend court. So the dates that we put in the motion for continuance are not dates. The defense is here, Judge, under the circumstances, whenever the court would allow us to be here and our expert would be available. The dates that we put in were dates that the state said all of their witnesses were available. So we're flexible, but the dates that we have suggested in the motion for continuance, we know that the state's witnesses.
All right, so, and what is your witness's expertise in?
He is our toxicologist. This case has 3 blood draws with different results. So he is actually probably more important than accident reconstructionist in this case, which is an intoxicant, obviously.
All right, so this is, I'm sorry, State, do you have any objections to the motion for continuance?
Not at this time.
All right, so the court will grant the defense's motion for continuance. This is going to be reset in November.
In the end, Judge Stephanie Boyd grants the defense's motion for continuance, resetting the case for November and requiring updated medical information on the expert witness. This ruling reflects a careful balance, acknowledging the defense's due diligence while maintaining oversight to prevent indefinite delays. The court also leaves the door open for alternative experts and even recorded testimony if both parties agree, showing flexibility within procedural boundaries. This wasn't a win or loss. It was a pause, grounded in fairness and necessity. What this case highlights is the constant tension inside real courtrooms: efficiency versus equity, authority versus impact, and structure versus human reality. Now we want to hear from you. Do you think the court handled this fairly? Or should defendants receive more protection from repeated delays? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
At November, there's going to need to be a date of when he's expected to be released. And if it's still undetermined, you may need to have another expert.
I will tell you, Judge, as soon as I get that information, we will be happy to notify the court and the state. Also, at this time, for due diligence, although he is in San Angelo, I would like to ask the court for permission to depose him in case he passes away.
Well, you need to confer with the state on that. Because the state will need to be present to perform their cross-examination. If that is something that both parties agree with, and there's no objection, we can do it by Zoom.
Thank you, Your Honor.
And then it could be recorded.
I want the court to be aware of the state. We have also, out of abundance of caution, already contacted other experts. We haven't authorized court funds for that, and I don't know that we should do that just yet. But I want everybody to know that we are doing due diligence, and I will actually send over notice of a proposed expert today.
All right, Ms. Ferguson, set this in November. Yes. And at that time, the court is going to need to have a date. All right, we'll be back on November 18th once you sign the reset form, your excuse.